Good afternoon, everyone. My name is Amy Groff, and I'd like to welcome you this afternoon to the National Apartment Association's webinar on what employers should know amid COVID-19. I'm the Senior Vice President of Industry Operations for the National Apartment Association. And in a continued effort to provide our membership with timely and relevant information amid COVID-19, we're producing a series of webinars which can be found at naahq.org/coronavirus. Today's topic is top of mind for our industry as we navigate through the requirements of the recent legislation focused on helping employers and employees throughout this pandemic. At this time, I'd like to direct your attention to the screen. Please take a moment to review our disclaimer. I'm pleased to introduce our experts in employment law. Our first guest is Mark Engel. Mark Engel is an employment attorney with the firm Lurch, Early & Brewer. He's committed to proactively helping for-profit and nonprofit employers minimize the risk of employment claims, establish sound and effective employment documents and policies, and resolve local, state, and federal workplace disputes throughout the Washington, D.C. area, applying more than 30 years of wide-ranging litigation and counseling experience. He firmly believes an ounce of prevention is worth a pound of cure and advises in-house counsel, business owners and executives, human resources professionals, and managers on a myriad of employment issues, including federal and state wage and hour laws, the Americans with Disabilities Act, the Family and Medical Leave Act, and anti-discrimination and harassment regulations. Our second expert is Paul Starkman. Paul is one of the leaders in the Labor and Employment Practice Group in Clark Hill's Chicago office. Paul focuses his practice on labor and employment law counseling, litigation, and transactions. And as a litigator, he has successfully represented clients in federal and state courts, as well as arbitrations across the country. Welcome, gentlemen.
Thank you, Amy.
This is Mark. I want to welcome all of you as well, and many thanks to Amy and her team for the invitation and for all of their assistance in putting on this webinar this afternoon. We're very grateful to them. They did so under unusual circumstances, which made it even more challenging. I also want to thank my friend Paul Starkman for joining me here today as well. Our agenda is to focus on the four major topics, which include the following: the new federal coronavirus statute, remote work considerations in light of COVID-19, accommodations and medical inquiries in light of COVID-19, and finally, layoffs, furloughs, and WARN Act issues in light of this pandemic. Paul's going to start us off momentarily with a discussion of the new federal coronavirus statute. I'm then going to follow with a discussion of remote work considerations and accommodation issues. Paul will return to discuss layoffs and furloughs. We'll then entertain some questions following our presentations, and then I'll follow up with a few concluding thoughts. So without further ado, I want to turn it over to my friend Paul.
Hello, everyone. Thanks again for joining us. My thanks to my friend Mark, and again, also thanks to Amy and her team. This is not an easy webinar to put together with everyone working remotely as they are, but here we are, and we welcome you to our webinar. So let's jump right in. What's the first thing to consider as an employer during this coronavirus? Well, one of the first things is, of course, the new federal employment laws that were enacted recently. They are really, the act is known as the Family First Coronavirus Response Act. That's a mouthful right there, but it's really two acts in one, which one of which is the Emergency Family and Medical Leave Expansion Act, which I'll call the FMLA Expansion Act during my talk. And the second part of this statute is the Emergency Paid Sick Leave Act. We'll talk about who's covered by these two acts, We'll talk about what's required in order for employees to take leave under these acts. We'll talk about the reasons for taking leave, what are the permissible reasons, and we'll talk about the rate of pay that they receive while on these paid sick leave. Paid sick leave. So we'll also talk a little bit about the tax credits that the IRS has approved for employers to get to help pay for the paid sick leave that they provide. So let's first talk about the this law, which was signed into law on March 18th. The law expands the Family and Medical Leave Act, which and includes paid leave for coronavirus or COVID-19 related reasons. The law creates an entirely new paid leave obligations for many employers. And as I said, it provides tax credits to help pay for this paid leave. There's many questions that still arise out of this this statute, but the Department of Labor is providing us with guidance on an almost daily basis. And we hope that that will help clarify what is right now a daunting task for employers to prepare to provide this type of paid leave. So when does this new law go into effect? Well, the Department of Labor has announced that the new law goes into effect on April 1st. That's next Wednesday. And it's scheduled to last until December 31st, 2020. So we're really talking about paid leave taken during between April 1st and December 31st, 2020. How will the Department of Labor enforce this new law initially? Well, according to their recent guidance, they have issued a statement that indicating that it will, quote, observe a temporary period of non-enforcement for the first 30 days of that after the act takes effect, so long as the employer has acted reasonably and in good faith to comply with the act. So there's a little relief there. However, before you get too comfortable that we have a month to get situated with this law, please understand that when the Department of Labor says good faith, they're talking about one violations are remedied under the law as quickly as practicable. The violations can't be willful, and then the Department of Labor has to receive a written commitment from the employer that it will comply with the law in the future. So I think employers need to be ready to comply with this new law as of April 1st. And what are the two parts of this Family First Coronavirus Response Act? Well, the first part, or at least the part that came first, is the Emergency Family and Medical Leave Expansion Act. And the second part is a add-on Emergency Paid Sick Leave Act. Let's talk about the general guidelines under the Emergency Family and Medical Leave Expansion Act. And we'll call that the FMLA Expansion Act because that's what it does. It expands on the FMLA. Which employers are covered under this new Emergency Family and Medical Leave Expansion Act? Employers with fewer than 500 employees will be covered by the act. An employer is covered if at the time your employee takes leave, you employ fewer than 500 full-time and part-time employees throughout the United States, including the District of Columbia and any territory or possession of the United States. However, so everyone under 500 employees will be covered by these new laws. However, there is a potential small business exemption. The Secretary of Labor has the authority to exempt small businesses with fewer than 50 employees from the requirements where such requirements would jeopardize the viability of the business as a growing concern. We don't know yet the details as to how this small business exemption will be applied, but for small employers with less than 50 employees, there may be this exemption if complying with these requirements would jeopardize the viability of the business as a going concern. So which employees are covered under the Emergency Family and Medical Leave Expansion Act? To be eligible for this leave, an employee must only have worked for the employer for at least 30 days. That's different from the FMLA, which has a 1 year, 12-month requirement plus 1,250 hours worked in the prior year. For this leave, the employee must only have had to work for 30 days. The only exemptions from this are healthcare providers and emergency responders may be excluded by either the employer or the Department of Labor may exclude those healthcare providers and emergency responders as well. So what are the requirements for paid leave under the FMLA Expansion Act? The reasons for leave is simple. There's one reason you can take leave under this FMLA Expansion Act. An employee is unable to work or telework due to the need to care for the employee's son or daughter who is under the age of 18 and the son or daughter's school or daycare is closed due to the coronavirus. How much leave is provided under this Emergency Family Medical Leave Expansion Act? The maximum leave is 12 weeks. That's 12 weeks total. However, the first 10 days of this leave are unpaid, and we'll get into that in a little bit as to how that will work with the Emergency Paid Sick Leave Act. However, during this 10-day period, an employee may elect to substitute accrued vacation or other paid time off for the 10 days of unpaid leave under this act. But employers may not require that employees do so. And we'll get into how this 10 days intersects with the Emergency Paid Sick Leave Act. So what's the rate of pay that must be used for leave during a leave under the FMLA Expansion Act? After the first 10 days, which is unpaid, leave is paid at a rate of 2/3 of the employee's regular rate of pay. That's 2/3 of the regular rate of pay for the number of hours normally worked. However, there is a cap of $200 per day and $10,000 in the aggregate. Employees with varying work schedules, you look at the number of hours that they were scheduled to work for the 6 months prior to the start of leave. What procedures must be followed during this FMLA Expansion Act leave? Well, employees must notify the employer of the need for leave as soon as practicable. That has the same meaning as under the FMLA, and it's as soon as they foreseeably know the need for leave. Once on leave, the employees may be required to follow your reasonable notice procedures, and those are usually contained in FMLA policies that exist now. The leave, if not used, will not carry over from year to year. The employee will not be required to search for or find a replacement while they are on this FMLA Expansion Act leave, and the leave, if not used, will not have to be paid to the employee upon termination of employment. It's not clear yet whether there will be new forms provided by the Department of Labor to administer this type of leave. As with most other employment laws, these new federal laws have anti-retaliation provisions that prohibit retaliation when an employee requests leave or participates in a complaint about a violation of one of these acts. So after the employee takes FMLA Expansion Act leave, what are the employee's rights to restoration to their former position? As under the FMLA, most employers will have to restore employees returning from leave to their former or equivalent positions, just like under the FMLA. However, employers with fewer than 25 employees may be exempt from this restoration requirement if, one, the position no longer exists because of economic changes or other operational changes caused by the coronavirus disease. The employer must make reasonable efforts to restore the employee to an equivalent position, and the employer has an obligation to make reasonable efforts to contact the employee during what's referred to as a contact period, but it's not defined. The employer must make reasonable efforts during this contact period to contact the employee if an equivalent position becomes available. So there is some relief available for small employers under 25 employees from the requirement that they restore employees returning to work if those jobs are, no longer in existence. So let's turn to the Emergency Paid Leave Act and see how that intersects with the FMLA Expansion Act. Which employers are covered by the Emergency Paid Sick Leave Act? Most private sector employers with fewer than 500 employees in the U.S. and its territories and possessions. What employees are covered by this emergency paid sick leave? This is different from the FMLA Expansion Act, which required 30 days of employment in order to get FMLA Expansion Leave Act. Under this new emergency paid sick leave law, there is no minimum length of employment needed to qualify for paid sick leave under the Emergency Paid Sick Leave Act. That's different from the other part of this statute. There is an exemption, again, for healthcare providers, and emergency responders may be exempted from the emergency paid sick leave, just like they are under the FMLA Expansion Act leave as well. So what amount of leave is available to employees under the Emergency Paid Sick Leave Act? Here, this is where we get into the intersection with the FMLA Expansion Act. Under the Emergency Paid Sick Leave Act, full-time employees may take up to 80 hours of paid leave for a qualified reason. And there's more than one qualified reason under the Emergency Paid Sick Leave Act, and we'll get to those in a minute. Part-time employees get the number of hours that they're regularly scheduled to work over a 2-week period. So during the first 10 days of FMLA expansion leave, an employee can take leave under the Emergency Paid Sick Leave Act, or they can use their accrued PTO under the employer's policy. It's the employee's choice. And this paid leave must be made available immediately upon the law taking effect on April 1st. So what are the reasons why employees can take leave under the Emergency Paid Sick Leave Act? There's 6 reasons. The first 3 have to do with the individual's own illness. The second, the 4th and 5th one have to do with the employee taking care of a spouse or family member or child. So reason number 1, the employee is subject to a legal quarantine or isolation order. Reason number 2, the employee has been advised by a healthcare provider to self-quarantine. Number 3, the employee is symptomatic and is seeking a diagnosis. The 4th reason is that the employee is caring for someone, a family member who is subject to a quarantine order or has been similarly advised by a healthcare provider to self-quarantine. And then the 5th reason is that the employee is caring for a son or daughter whose school or daycare is closed due to the coronavirus pandemic. Again, remember that this is leave. We're talking about here leave during the first 10 days. And one of the reasons is caring for a son or daughter who's home due to the coronavirus. That's also the reason why they can take the 12 weeks of leave under the Family and Medical Leave Act, Expansion Act, but they only get 12 weeks total. So an employee can take emergency paid leave, sick leave for the first 10 days, and then 10 weeks of FMLA expansion leave if they're home with a child whose school is closed for the coronavirus pandemic. And an employee does not get to take 10 days of paid sick leave under this emergency law for one reason and then take another 10 days for another reason. They get 10 days total under this law. What is the rate of pay? If the employee is taking leave for their own sickness, they are paid at their regular rate of pay. There is a cap of $511 per day or $5,110 in the aggregate. Employees who are caring for a family member or a child receive 2/3 of their regular rate of pay, capped again at $200 per day and $2,000 in the aggregate. Again, just so that's where the overlap is between the paid sick leave and the FMLA expansion leave. If they get 2/3 of their pay if they're caring for a son or daughter who's at home because of the virus. So what procedures must be followed under this law, the emergency paid sick leave law? Again, the employer may require employees to follow reasonable notice provisions and procedures. The employer is not required to find a replacement. The employer is not required to use accrued PTO before using leave under the emergency paid sick leave. And again, as with the other type of leave, emergency paid sick leave does not carry over from year to year and is not paid out upon termination. However, the interplay with your existing PTO or paid time off policies is that employers cannot change already existing paid leave plans to avoid having to pay the paid leave under these statutes. The employee would be entitled to leave under the statutes and under the employer's PTO policies. How will this act be enforced? A failure to pay for the leave will be a violation of the minimum wage provisions of the Family and the Fair Labor Standards Act, and a failure to provide paid leave under the FMLA expansion leave will be deemed to be a violation of the FMLA itself. There's also liquidated damages for willful violations of these statutes. So quickly, so I know I'm overreaching my time, the tax credits that employers can claim for paid leave are a dollar for dollar for the required paid leave, which includes the cost of the employer's health insurance premiums during this leave. So you get 100% coverage on a dollar for dollar basis of refundable tax credits for the amount of leave that you provide to your employees under these statutes. And the IRS has recently announced that employers will be able to immediately pay themselves for this paid sick leave by retaining taxes that would otherwise be withheld from employees' paychecks. So rather than paying this withholding to the IRS, you'll be able to retain that and also be able to get expedited returns of any taxes to the extent that it doesn't cover the amount of paid sick leave that you've inquired. So the bottom line is you can pay yourself back through the withholdings that you would otherwise have to pay to the IRS. So that's the essence of the and the highlights of the new paid sick leave statutes. I want to now turn it over to my good friend Mark, who will take us through managing remote workplaces during this pandemic.
Thank you, Paul, and thanks for that excellent summary. The COVID-19 has effectively required employers to consider remote work alternatives in a way that they probably haven't had to do for as long as I can remember. But any decision to move even a few, some, or all of an organization's employees to a remote work status, even on an interim or a part-time basis, requires a myriad of decisions and considerations, including a number of which I'm going to discuss in just a minute. But before I delve into that, I want to talk about just the basics. When people use the term remote work, it's often used interchangeably with telework. Both of these concepts kind of fall within a larger umbrella of alternative work arrangements. In a nutshell, teleworking or remote work is the practice of working at home or at another site instead of physically traveling to the offices of the company or to a client or a customer site. As a general proposition, and we'll talk about the exceptions in just a second, employees do not have a right to work remotely. There may be a right for an accommodation to work remotely under the ADA, the American with Disabilities Act, or comparable state and local statutes, in a situation where the individual needs a reasonable accommodation, in this case due to symptoms associated with COVID-19. As a general proposition, it's a great idea for employers to have a remote work policy. If they have one in place, really important to dust it off, review it, and make sure it's applicable to the current facts and circumstances that we have today. I'll talk a little bit more about that in just a second. Can employers encourage or actually require employees to work remotely? Again, if you'd asked me that question several weeks ago, I might have a somewhat different answer, but as we speak today, the answer to that question is yes. Remote work arrangements are considered an effective infectious disease strategy. The impact of government shutdowns, closures, mandatory limits on gatherings have all made that, for all practical purposes, a reality that all of us are facing today to one degree or another. Under the ADA, employers can exclude employees with disabilities in the workplace if they pose a direct threat to themselves or to others. And I'll talk a lot more about that in just a second. The next inquiry in this sort of decision tree is really, can employees request to work remotely? And as I mentioned, in this circumstance where we find ourselves, it's really a bit of a fait accompli for individuals, except for folks who are in essential personnel or in situations where the positions simply do not lend themselves to working remotely. But if an individual in a more conventional circumstance were to request the right or the ability to work remotely as an accommodation because they're experiencing symptoms to COVID-19, that would involve the traditional ADA interactive analysis. And remote work can be a form of an accommodation unless it poses an undue hardship for employers. The key operative concept here is the interactive process, which is just a fancy way of saying you've got to communicate with the employee. It's a back and forth, it's a discussion. It's about understanding the nature of the accommodation, the reasons for the accommodation, and in most instances requiring some medical support, healthcare support for the requested accommodation. The relationship between the ADA and the remote work is really important to understand because it pervades the remote work concept, the essential personnel concept, and a few other issues that are very much a part of the landscape now. The ADA regulates inquiries and medical examinations that employers can conduct for employees and applicants. It prohibits, in general, employers from excluding individuals with disabilities um, unless they pose what is known as a direct threat. And again, I'll talk about that in just a second. And it has a reasonable accommodation piece to it. Whether COVID-19, and it certainly does now, rises to the level of a direct threat is going to depend upon the facts and circumstances. As we sit here today, unquestionably, it's the case. As the COVID-19 subsides, hopefully much sooner rather than later, that analysis will become a little bit more challenging. Okay, but right now, where we sit with the CDC's issuance of rulings and directives, directives from local and state authorities, that's providing objective evidence for the need for a disability-related inquiry or a medical examination, which is really important. In other words, in plain speak, it's giving employers a bit of a hall pass to ask questions which several weeks ago, before this pandemic, they would not have been able to ask, or not have been able to ask so directly and so regularly. All right. At some point, as I said before, we're going to shift from the situation where remote work is becoming all but inevitable, except for those that have to report to work because of the nature of what they do and because they're essential personnel, to a more conventional analysis of when is a position suitable for remote work. Okay, and that's a really important discussion to have, and my advice for best practice is to have that discussion now, because the COVID-19 is going to subside, as I said, hopefully much sooner, and we're going to be faced with a situation where we're dealing with remote work issues. How do you make that determination? Well, you want to look at the tasks. Does the job have a clearly defined task? Can the work be done at home? Can the work product be effectively measured? Would working at home create an undue hardship? Is the technology available to support the remote work concept? How far is the commute that individuals have? All these are factors in terms of gauging the suitability of a particular position to remote work status. Again, I would encourage you to really look at that issue very closely now, because it's going to resurface again and again when the COVID-19 abates. If we have somewhat of a second wave of this to some degree, and more generally, in my view, what I'm reading and what I'm seeing is that the workplace as we know it, I think, is going to be changed. And I think the winners in that environment are going to be folks who can adapt to the remote work aspect of getting things done, to virtual work options, and to all other alternative work strategies, which are going to be demanded by the marketplace, by clients, and by customers to a great degree. Preparing for remote work, critically important to prepare for it and to manage the remote work so that it's effective. The preparation involves, as you might suspect, looking at infrastructure issues, looking at technology, security, privacy. How are we going to handle security risks? Do we have systems in place to govern data and securing data? Have we reviewed agreements with clients and customers to make sure that they allow for remote work? Okay. Are we managing the expectations of clients and customers to determine whether or not they're going to be in lockstep with certain individuals working remotely? And if so, under what circumstances? What expenses are going to be paid for by the employer and what need to be assumed by the employee? What type of electronic devices can be used? All these things go into the analysis of preparing for remote work. Just as critically is the concept of managing remote work. And here's where some of the heavy lifting really occurs. Supervisors and managers and the executive team need to train folks on how to work remotely successfully. Usually most employers, in my experience, don't have a tool book or a handbook for working remotely in a very successful, effective, and economical way. Look at the job descriptions. Look at the job duties. Make sure they're current. Make sure that we're characterizing individuals correctly as exempt or non-exempt. Make sure you have procedures for regular meetings and call-ins and communication. Okay, if there are job performance deliverables, reports, write-ups, messaging to clients and customers, make sure that those issues are all addressed. It's hugely important to get in front of these issues and to be as proactive as you can for a variety of reasons. And again, remind employees that in the more conventional environment that we're going to return to, working remotely is largely a privilege and not an entitlement. Compensation issues, again, critically important. We read, we hear, Paul and I in our practice of foot faults and mistakes and oversights that employers make because they're not tracking the hours that folks are working remotely, particularly for non-exempt employees, okay? Got to make sure that they're tracking their hours correctly. One thing that I recommend to clients is use some type of timesheet certification where each week the non-exempt folks who are working remotely, just as the case for those who work not remotely, and work in the office or the client site, are representing to the employer that all the hours that they worked are true and correct so that they can be paid accordingly. It's a great tool, a great device to manage expectations, to manage budgets, and to avoid unforeseen overtime claims. Prohibit working off the clock if you don't want folks working outside their scheduled hours. And by all means, enforce and distribute information about overtime policies. Critically important. Potential liabilities. There's liabilities, as I just mentioned, under the Fair Labor Standards Act, including overtime claims. There's the possibility of workplace injuries when folks work remotely. There's the possibility of a loss of data. And you've got the whole panoply of potential wrongful termination and adverse employment actions that arise out of the remote work status. How do we measure performance? When do we measure performance? And again, you want to make sure that employees who work remotely are going to be held to the same standards and requirements for all practical purposes as those who do not work remotely. Insurances. Look at your employment practices liability insurance. Many of you have it. For those of you that this is a new concept, it's a type of insurance designed to cover employment-related claims. But there's a huge caveat to that concept because the EPLI policies, as they're known, can come with different types of coverages. Make sure to review them to ensure that they provide the types of coverages for wage and hour, for workers' comp, and all the related other claims. And workers' comp actually may be under a different policy. But make sure they have coverages for the different types of claims that can arise from the remote work concept. Your general liability policies. Is there coverage for loss of data? Is there coverage for loss of confidential information? Your agent, your broker, your insurance folks who assist you with these issues can work with them and make them part of the process of ensuring that if you're changing the workplace dynamic, that your insurances are moving in lockstep with that new reality. Best practices.
Hey, Mark, before you move on to best practices, one form of insurance that people might want to look for or consider is business interruption insurance. It's not as common as EPLI and some of the other insurances that you mentioned, but it covers the types of business interruptions that occur, you know, when you have something like this type of pandemic. So it's something to consider.
Yeah, absolutely, Paul. It's a great point. Thank you for reminding me. But again, and what I'm hearing anecdotally, I'm not sure about Paul's experience, is that clients have had varying degrees of success in making claims under those policies, but at least explore it. Okay, figure out if you have it and you're having an issue where there's a possibility for a claim, making sure that you're giving the appropriate notices, managing the time periods so that you can perfect that claim. If you don't have that type of coverage, again, Paul's 100% correct. You know, have that dialogue with your insurance representative to make sure you understand what the ramifications are for that type of coverage, how it might be triggered, and so forth. Best practices. If you're pulling out your pen and pencils now, again, here's the list of the best practices. Create a remote work policy if you don't have one. If you do have one, update it to make it relevant to the situation that we have now. Consider using a remote work agreement as a condition for individuals working remotely. And that'll set out the expectations for employees and supervisors alike. Outline in your remote work policy the criteria under which you normally use to consider whether somebody can work remotely. Bake into that analysis a lot of flexibility. Don't lock in, don't bind yourself to a rigid set of factors, because whether someone can work remotely or not is going to be highly dependent upon what they do, when they do it, what the client needs are, what the business needs are. You want to have the flexibility to have folks work remotely, to change that remote work relationship, to modify it, and to end it as circumstances warrant. Communicate the overtime policy and do it over and over. If you have people working remotely for the first time, take a look at the hours. Coordinate with HR to make sure you're tracking the hours, to make sure we don't have a hidden compensation explosion in terms of hours that we didn't plan for. Okay? Establish regular times for conferences and supervisors and employees, for supervisors and employees rather. Make sure you look at the insurances, as I just mentioned. Make sure that to the extent that you can, and this is going to be very fact intensive, that you're managing client and customer expectations. Okay, if you're concerned about a client or customer hearing from an employee working remotely for the first time, and that's going to create heartburn for somebody, better that you get ahead of that issue and have that conversation with the client or customer ahead of time. Okay, mandate the timely reporting of accidents and injuries, critically important. And then the last item I think on the best practices list is to, as I said earlier, to use this really as, ironically enough, an opportunity to rethink and re-strategize alternative work possibilities in the short term, the midterm, and the long term. So let me pivot a little quickly, go through.
Before you pivot, Mark, if I could hold off on that pivot, if you would. One more thing is, this is an excellent time to review and revise any kind of disaster preparedness plan that you may have had in effect. A lot of people are, doing things and changing operations on the fly on an ad hoc basis. And a lot of times they found that they don't have the technology in place, or they don't have the resources to provide people for something like this, where they're, more and more of your workforce may be required to work from home as more and more communities are implementing these shutdown orders, and more workplaces are encountering people who have in fact, been exposed or have come down with the coronavirus. So it's something that you need to constantly be looking at and revising and figuring out, how can we do this better? Maybe not the next time, but as this particular pandemic continues, and it may continue for quite some time, we need to be thinking down the road and not just reacting to the crisis of the day, which I think a lot of people are right now.
Yeah, I think that's, Paul, it's a terrific point, and I just really want to echo what Paul said. I can't overstate the importance of that. Our managing partner, Steve Robbins, who I think is on this webinar, Dave Anderson, who may be on the webinar, are preparing plans for virtually every contingency that you can think of, and then some, to try to stay ahead of these issues. And the planning is just incredibly important. Related to that issue, and Paul, thank you for reminding me, is the whole concept of essential personnel. It's a broader discussion, and one that we could have for a much longer period of time. But let me just say this. In various states, we have one in Maryland, there's one in Illinois, and throughout the country, there are shutdown orders, except for folks who fall within varying definitions of essential personnel. And those definitions can vary, but, and that's a separate challenge in and of itself. And you should be working with, counsel or people who can assist you with that discussion. But more broadly, as it relates to remote work, again, part of the remote work challenge is figuring out, who are your essential core personnel that need to be there? Can there be teams set up? Can there be backup teams? Can teams be split into a column A and a column B? And are we looking at that issue critically to make sure that it's mindful of the employer's needs, but also respectful of the anxiety and concerns that employees justifiably have? So let me talk a little quickly about the accommodations and piece of this and medical inquiries. I've talked a fair amount about it already. I want to make sure to leave some time for Paul to talk about layoffs and furloughs. But again, summarizing from the ADA really is relevant to pandemics in three major ways. First, it regulates disability-related inquiries, as I just mentioned. Second, it generally precludes employers from excluding individuals with disabilities unless they pose a direct threat, which we've talked about. And then there's an accommodation piece, all right? The ADA analysis
Amy, will
In
you
my
move
prac-
to the next slide, please? Sorry, Mark. Didn't
No
mean to
worries.
interrupt.
In my practice, and Paul and I work closely on a number of matters together. I think we've been talking about these over the past week. You know, it sort of raises a number of questions, and let me try to go through some of those quickly that we're seeing on a fairly regular basis in our practices, and I suppose you're going to be getting, if not now, then soon enough. Can an employer ask about COVID-19 symptoms? The answer is yes. Employers can make inquiries about medical symptoms and medical conditions if it's job related and consistent with business necessity. The EOC has explained that particularly because of the pandemic and an earlier pandemic a number of years ago, that question, which could not be asked several weeks ago, can be asked if there's a clearly objective basis for doing so. And again, we have that now through the CDC and the local and state issuances of, self-quarantining, sheltering in place, and so forth. Now, remember, that could change and will change soon enough. So the ability to ask those types of questions may be a fluid dynamic that you need to be mindful of. Secondly, can an employer ask about exposure to a person infected with COVID-19? Generally, yes. Again, for the same basic reasons. But again, you want to share that information with only with those with the need to know. And also keep in mind that any information that you're obtaining from employees about medical conditions needs to be kept confidential. Really, really important. Okay, there's ways to disseminate information if someone does test positive, and it's a little bit beyond the scope of this discussion today, but again, in general, respect the privacy to the greatest extent that you can. May employers require self-quarantining? Yes, they can. And of at least 14 days certainly seems reasonable under the circumstances. Can they direct people to stay home if they have symptoms? Again, yes, because that really would not be a medical related inquiry under these circumstances. Paul and I have both gotten questions about taking temperatures of folks. Again, under this current environment that we're in, yes, as long as this exists, I believe that you can do that because it helps to discern whether someone is a direct threat. And again, we're going to be relying and looking regularly at the CDC and the local and state and other federal issuances of notices about this. But again, take the issue of taking a temperature with a bit of a grain of salt, if you will, because as I understand it, I'm no scientist and certainly no doctor. Sometimes those symptoms are not going to manifest immediately, and therefore taking the temperature may be of limited utility. Can employers require a doctor's note when someone's been to an affected area or exhibited symptoms or been near or close to somebody that has? Yes. Again, my guiding thought here is I'm going to err on the side of safety and health when it comes to a potential employment claim. The protective gear is a much broader discussion. I understand from Amy, you may have addressed that in a different webinar. The general rule of thumb for protective gear is that that's a fact-specific inquiry, and that employers can be required to provide protective gear as a form of a reasonable accommodation. Can employers ask if someone who's been absent from work if they suspect that it's for a medical reason? Yes, in this environment. It's not considered a disability-related inquiry. And finally, can you ask if somebody has a pre-existing condition that would make them more susceptible to COVID-19? The answer to that is no, okay? That's an area where you have to show great care because of the ADA. Best practices, let me go through those quickly. And by the way, I think as Amy's gonna indicate later, longer outlines that Paul and I prepared will be available, I think, on NAA's website, which will get into these issues in greater detail. But best practices, train the managers on ADA issues and how to identify them and put their hand up and ask for help if these develop. Check your insurances, as I mentioned. Establish a gatekeeper, preferably through HR, if people who have been out of the office that they need to coordinate with to return to the office. You just don't want people who have been out deciding for themselves that they're okay to return, even if they have a doctor's note. As I said, err on the side of safety and security. Communicate with employees. Develop contingency staffing plans, as Paul just mentioned. Maintain confidentiality to the greatest extent that you can, and update your ADA and related policies accordingly. So let me turn it back over to Paul for a discussion of layoffs, furloughs, and related issues, and then we'll hopefully have some time for some questions.
Thank you, Mark. That was great. I appreciate all the excellent insight. Let's talk a little bit about layoffs, furloughs, pay reductions, and other legal implications that flow from those. Those are, again, it's important to recognize that the decision to do a layoff, do a furlough, and we'll talk about what those mean in a minute, but the decision has to be done on a case-by-case basis. There's no one-size-fits-all formula for doing these kinds of things. And by layoffs, I mean where you completely terminate their employment, you end all benefits, you take the person off the employment rolls. With a furlough, I consider them to be, or at least for purposes of this talk, I'm considering a furlough is where you send somebody home with or without pay, but you may continue to provide them with health coverage and allow them to use other benefits like paid time off while they're on furlough, and that create different risks in and of themselves. Furloughs, in my view, are from a humanitarian standpoint, that's often a great alternative if you're able to do that, and if you're able to make sure that you're able to continue their health plan coverage while they're out on furlough. And because some plans they can be out on administrative leave, and that will preclude an end of coverage for them. Others have 120 days absences, will not be considered them as a basis to terminate coverage. So it's important to make sure that if you're going to continue, and if you want to try and continue the health coverage for your employees during this difficult time period while they're not working, that you check your policy and check with your broker and make sure that in fact that you will not end up with a situation where they lose coverage under the terms of the plan. You should have provided them with COBRA notices, but you didn't, thinking that they would be covered under your general medical plan, and you run into liability that way. So be careful that with furloughs that no good deed goes unpunished, and you make sure that you're going to be able to do what you intend to do, and that you won't have any unintended consequences. With a layoff, it's a different situation. You're laying them off. It may be permanently, it may be temporarily. You may have every intention of bringing them back, but given this pandemic, we just don't know, and we don't know how long these people will be out, and when, if ever, we'll be able to bring them back. So you need to be careful if you're going to be doing any large-scale layoffs, that you comply with the local laws regarding, payment of final compensation, payment of vacation pay if you're in a jurisdiction that requires that. There's certain paid sick leave that may have to be paid in certain jurisdictions, and in certain jurisdictions there may even be an entitlement to some kind of severance package. Most states don't have anything like that, but it's important that you understand that if you're having widespread layoffs across the country, that you definitely need to look at the local laws, both from a state level and a municipal level, to see if there's any, traps for the unwary or gotchas in those local laws. As a general rule, layoffs, large-scale layoffs, fall within the what's called the Workers Adjustment and Retraining Notification Act, which is also commonly known as the WARN Act. It's something that companies need to keep in mind, and they need to recognize that not only is there a federal WARN Act, and again, I'm sorry to have all these acronyms flying at you, but under the WARN Act, there's a federal WARN Act, and many states have mini WARN Acts that have different provisions and that have differing requirements and penalties for different kinds of layoffs. Large-scale layoffs, typically under the WARN Act, if you've got 100 or more full-time employees, then you'll be covered by the WARN Act. Other states, like my state of Illinois, has a mini WARN Act that kicks in at 75 full-time employees, not including part-timers. And it's unclear, though, whether all those employees need to be in Illinois or not. So it's, there's ambiguities under that state statute as to how you count your employees. So, recognize that this liability is out there, and the liability under this statute is that if you're having what's called a mass layoff or a plant closing, and typically those involve 50 or more employment losses, employees suffering employment losses, then you may have WARN liability, which means that you're supposed to give 60 days notice before you lay these people off. And if you don't, you're liable for the pay and benefits for the period in which you did not provide that notice. So you have WARN Act notices that you must send out for large scale. You may have to send out for large scale layoffs. The good news with WARN is that typically, if your layoff is not going to last 6 months, if it's for 6 months or less, that's not an employment loss, and you don't have to provide the WARN Act notices for those types of short-term layoffs. However, that's not true of other state laws. So it's important to keep in mind, again, that you're looking at not only the federal WARN Act, but the state WARN Act as well, because states like California apply even with short-term layoffs and don't have that 6-month grace period that the federal law has. So it's something to keep in mind as you're making, large-scale decisions regarding your workforce. These conditions are something that you want to make sure that you're on sound ground before you start laying off your employees, because they're going to be aggregated over a period of time. Typically, it's within a 30-day period, but there's also a 90-day aggregation period that may apply under certain conditions. So it's just something to be aware of, that if you're making large-scale layoffs, that you're thinking about the WARN Act and making sure you're in compliance with it. So I know we're getting close to our time.
Yeah.
I want to leave a little time for question and answers and best practices. And I'll turn it back over to Mark.
Paul and Mark, thank you so much. You've provided us a wealth of information today. There was so much great information that you were able to share with us today. And it's 3 o'clock, and I really had hoped for some time for questions. I know we've got a lot of questions in our chat and on our Q&A. I promise our audience that I will gather all those questions and circle back with Paul and Mark, and we'll put together an FAQ document, as well as provide a recorded copy of this webinar And as Mark's alluded to, they have a full document that will go into all the details that they shared with you today. So we'll make sure we provide that to our audience and our members at NAA, so you'll have a resource moving forward. I really appreciate your time and effort, Paul and Mark, and I thank my audience today, our viewers and our members, for joining us today. I hope everyone stays safe and well, and I hope you have a great rest of your day. Thank you, everyone.